Good afternoon to all. Honorable Speaker, Shri Vijay Hansaria, Senior Advocate, former Vice President of SCBA. Honorable Speaker, Ms. Pavni Mahalakshmi, Senior Advocate, President of Supreme Court Women Lawyers Association. Respected Shri Manoj Swarup, General Secretary of the Society for Socio-Legislative Reforms, SLR. The convener of the seminar, Shri S.S. Nehra sir, and my team members of SSLR, and a very special audience, a very good afternoon to one and all. I, Dr. Shilpa Bagade, Joint Secretary of SSLR, feel privileged to welcome you all on the behalf of the entire team of the SSLR for the seminar on the role of bench and bar in socio-legislative reforms. We are grateful to all for being a part of this elite event. Bar and bench are the two sides of the same coin when it comes to social legislative reforms. The bar's legal expertise and advocacy, coupled with bench, judicial authority and interpretation, are essential for creating a just and equitable society. Function of both is supplementary to each other. According to J.H. Wells, writing in his work entitled The Work, Wealth and Happiness of Mankind, every individual performs his role in life for a reason which impels him to do so. That is reason to be found in the concept which the individual has of himself and his mission in life. Let's come together and deliberate on the topic, that is role of bench and bar in social legislative reforms for the benefit of the society. I seek a permission from the chair of the seminar to observe silence for the 2 minutes. We will observe 2 minutes silence to pay tribute and in the memory of those who lost their lives on account of the act terrorism in Pahalgam in the Union Territory of Jammu and Kashmir. Kumar to present floral bouquet and a memento as a token of respect and appreciation to our chair, Justice Sri Rajesh Tandon, former judge of the High Court, Uttarakhand. I now request Shri Amod Biduri, Advocate, to present floral bouquet and memento to our Honorable Speaker, Shri Vijay Hansaria, Senior Advocate, former Vice President of SCBA. I now request to Ms. Sundari to present floral bouquet and memento as a token of respect and appreciation to our Honorable Speaker, Ms. Pavni Mahalakshmi, Senior Advocate, President of Supreme Court Women Lawyers Association. I now request to Ms. Charu Singhal to present floral bouquet to Honorable General Secretary, SSLR, Shri Manoj Swarup sir. I request to Sri Neeraj Dutt Gaur, Advocate, to present floral bouquet to Ms. Rachna Srivastav, Vice President, SCBA. I request Dr. Alim and Mr. Amod Biduri, Advocate, to present floral bouquet to Ms. Sushmita, Treasurer, SCBA. Instructions. I request Advocate Sanjeev Kumar to present a floral bouquet to Mr. Ranveer Yadav, Senior Advocate. We have a person among us who is the advocate on record. This person is none but our very own secretary and the convener of the seminar, Sri S.S. Nehra, advocate on record. I feel privileged to request him to welcome you all with his words of wisdom. Sir, please.
Honorable Chairman of our society, Sri Rajesh Tandon ji, our guest of honor, Sri Vijay Hansaria ji, our guest of honor, Mahalakshmi Pavni ji, Senior Advocate, President of Supreme Court Women Lawyers, Ms. Rachna Srivastav ji, Sasmita Tripathi ji, Sri Ranveer Yadav ji, and all friends here, and team members, Satish Pandey ji, Dr. Prabhat Kumar ji, Somveer Deswal ji, Neeraj Dutt Gaur ji, 𝐒𝐿 Gautam ji, Sundari Advocate, Pradeep Yadav, Amod Bidhuri, and all the team members who are here. I welcome all the members and the dignitaries here, and I expect and respect that this seminar will do a very fruitful job today, and I welcome all, and we have to start the function, and I am giving the dais again to Dr. Shilpa. Thank you very much. Welcome all.
Thank you, sir. Moving on, we have among us a person who is an advocate on record, a scion of an illustrious judges and advocates family of Swarups of Prayagraj. It is my privilege that I did my training of advocate on record under his invaluable guidance, and he had 5 decades of practice in the Supreme Court of India. This is esteemed personality is our own General Secretary, Ms. Shri Manoj Swarup sir. I feel honored to request him to acquaint you all about the Society for Social Legislative Reforms. Sir, please.
Friends and colleagues, my job in this function is to introduce the society to all of you. Some of them are already acquainted with this activities of the society, and the others who are not associated with these societies' activities. I must tell that first of all, I must tell that when it was born, the society was born and registered in the year 2000. It was already 25 years, and it is a silver jubilee for this, as it is pointed out by this. It is there. The brochure of this will reach to all of you after some time, but I must tell that at that time, in the year 2000, the society was under the presidentship of Justice S.C. Agrawal, retired judge of this honorable court, and enjoyed the patronage of Justice V.R. Krishna Iyer. Most of you know his name. Justice V.B. Reddy, the former Chief Judge of the Supreme Court, and then Mr. Ravi Ray, who was the Speaker Lok Sabha. So this was the team, along with many other important persons, one of whom was Justice R.C. Srivastava, whose daughter is present today here, so that this reflects that this has now a old and established society where the next generation is also forming part of this here. And here is his daughter. The aim and objects of this society, those were also will be circulated to you, and the chair and president of the society, he will give the details of those aims and objects of the society. Probably all of you will be interested in that, and after that, most of you, I believe, will come and support the society and its aims and objects, which is very, very relevant in the present day society. And that is why today, instead of bar and bench, we have chosen to give it the name of bench and bar, because bench is playing a very crucial and important role today as on date for legislating also for the different kind of laws which are the social relevance. Most of the PIs to be filed nowadays clearly show that the courts are very active in protecting the rights of the individual of the society, not only the society as a whole, but even of the individuals to society. That is one of the most important roles of the courts nowadays. That is one of the most important thing which is to be followed up and done, which we will like to do. As far as the activity is concerned, our aim and object was earlier in 2000, when the society was started. I must tell that Justice S.C. Agarwal, he himself was closely associated and participated in this society's preparation, and aim and objects are finalized under his able guidance. After that, there are many judges and advocates of that time. They were associated with the society. After some time, we also had many societies pass resolutions and send it to the relevant department, including the law ministry and other relevant authorities who may take into account the views of the society and the members of the society who passed it in the form of the resolution, and which was at that time was given. After some time, I must tell you that we had decided at that time that the object is that the society may start with it to create mock parliament session or assembly sessions, and to take up any other sort of a bill-like resolution and to deliberate on it from this side and that side, and finally pass a resolution in the form of an act or law, and to be passed on so that the public opinion may go. Nowadays, after that, when we had, in meantime, there were some problems of some kind, like it is nowadays very easy to communicate. At that time, there were some problems. But the idea was to have that conference in a form of the parliament and sometime we passed it on, but finally after that it could not be carried on because of certain difficulties, which I don't want to enumerate at the moment. But then we worked closely with another organization, that is the Federation of Indian NGOs working for United Nations, in short, FINCUN. It was under the presidency of Ramesh Chandra, who was the president of the World Peace Council. Many years it worked in close association with that, and about 100 societies were part of it. And a number of resolutions and other things were passed on to the government and the authorities which may take into consideration while making the law. Now that after Mr. Ramesh Chandra left it because of the old age, the society that could not continue, and therefore now it is a need for us to regenerate it, and with all support of all of you and seeing the crowd here, there is no doubt in my mind that with now on with the same object, now it is more relevant, and then it is the support of so many persons, whether it is the junior advocates and the other persons of the society, which particularly in this conference are not here, because we try to confine it to the advocates in this way to start again and to bring it to the society as a whole. And we hope and trust that all of you, after finishing this conference and knowing much more about it with the esteemed speakers here, so that you may also participate in this as far as possible. And thank you all for this.
Thank you so much, sir, for your thought-provoking address. Has set a perfect platform for our guest speaker. We feel privileged to have among us distinguished speaker who is the senior advocate in the Supreme Court of India and is a known constitutional expert. He has started his career as a lawyer in 1980 in the Supreme Court and became advocate on record in 1985. In the year 2000, he was designated as a senior advocate by the Supreme Court of India. He was elected as a vice president in the Supreme Court Bar Association in 2004. He was appointed as a member of a National Legal Service Authority in the year 2013-2015 and again 2019-2021. He has authored many books: Writ Jurisdiction, The Chronics of Indian Constitution, Juvenile Justice Act, Manual for Stakeholders, Sixth Schedule to the Constitution relating to administration of tribal areas in Northeast India. He has also been appointed by the Supreme Court as an amicus curiae in martial law relating to detention of mentally disabled prisoners in jail, Malik Mazhar Sultan pertaining to monitoring and filling up vacancies and building of infrastructure in subordinate judiciary across the country, Ashwini Kumar Upadhyay for expeditious trial of criminal cases against MPs and MLAs and their permanent disqualification upon conviction. He has delivered a number of lectures at various forums of repute: Freedom of Movement in a Post-COVID World, Our Internal Passport on the Rise, delivered at Commonwealth Law Conference, Goa 2022, The Sixth Schedule, Visionary Perspective of Meghalaya, delivered at Meghalaya High Court, Shillong 2022, Electronic Agronomics and Judicial Intervention, delivered at Indian Law Institute, Assam Chapter at Guwahati High Court 2022, Judicial Independence, Perspective, Accountability and Challenges, delivered at Orissa High Court Bar Association, Cuttack 2021. This is widely acclaimed personality is none other than Shri Vijay Hansaria sir. I feel honored to request him to address you all. Sir, please.
See, we earn our livelihood by standing. So the more we are standing, that means the sitting we don't get fee. When we stand, we get fee. So it's good to see standing councils all around. I'm also standing, so don't mind standing. And that also shows the popularity of this organization. Normally, I was telling my colleagues that please come. Otherwise, I don't think there may be too small a people. आप लोग 2-4 ही लोग रहेंगे शायद देखने के लिए आ जाइए. But then it's big cheers to the organizations SSLR that they are so popular among the members of the bar that they expected perhaps 100 people and we are about more than 200 people here. So, but then I stand before you at a very sad day. I'm in grief. All of us are in grief. Let's take some resolution. We'll go to this subject later on. We'll not allow the country to be influenced by these acts. We must condemn all sections of the society, must do. Forget about the religion, we are all one. We are all from across all the religion, we are one. How can a few 4 or 5 people can divide this country? Their whole attempt is to divide. They cannot succeed. Let us resolve they will not succeed. And we will not let them succeed. Really disheartened for all of us. I asked Mr. Bhattiji whether we are continuing. He said that yes, we will continue. We will demonstrate that none of our activities will stop by these acts. People were taken out, say that I'm killing you, tell your Prime Minister. All right, our Prime Minister, our country will tell, each one of us will tell them. We'll give a revenge. We will have to stop this. We will stop this. Even if any one of us get the bullet, don't worry, I'm not worried about it. I'm so sorry I got influenced by this. Justice Rajesh Tandon Saab, the president of today's organization, my co-panelist Mahalakshmi Pawneji, a very respectable member of the bar. Manoj Swarupji, our distinguished colleague. I've been for 45 years, I've been colleague with Lilita College and Manoj Swarupji. It's good to see and meet them after a long time. Mr. Nehra Saab, convener of SSLR, my colleague here, who has been comparing. Bhattiji, Rachna Srivastava ji, Ranveer ji, Sasmita, my colleague, the other members of SSLR, my dear friends, colleagues. Today we are discussing a very important issue, role of bench and bar in socio-legislative reforms. What can bench and bar? Legislation is legislator's jurisdiction. Today we have a lot of debate. Judiciary must not go into the domain of legislature. They must do what they are expected to do. Question is, what are we expected to do? What is the bench and bar expected to do? Does our duty ends by adjudicating the disputes or something beyond that? I'll give you two examples where the bar and bench have made a lead role which has culminated into legislation, and two more where something needs to be done. First is regarding education. Education is the key of civilization. Without education, nothing can happen. We can remain in forest, we can remain wherever we are. Education is very, very important. And when I was reading this, I found out that the draft constitution, Article 36, contained a mandate: every citizen shall be entitled to free education. Unfortunately, that was not carried out in Article 45 of the final constitution we adopted. It became only that the state will make an endeavor to give free and compulsory education within 10 years up to the age of 14 years. It deleted that part of the provision which says every citizen is entitled to free education. And deletion was because one of the members says it is directive principles, it should be in the fundamental rights chapter. Wherever it is, it was a part of the constitution. So it got deleted. But then before that, way back, 100 years back, in 1893, we had Prince of Baroda, 𝐒𝐨𝐜𝐢𝐞𝐧𝐜 𝐷𝐿𝐼, who made it compulsory for free education up to primary level. We had 1910 Act, 1918, where Vittalbhai Patel in the Bombay municipalities, Bombay area, brought out a legislation where made a compulsory legislation for free education. And even went further, that even the parents were penalized if they don't send the children to the education. That was one of the debates when we took up this 86th amendment which made this. But what I'm saying that education has been thought of decades back. It was there in the draft constitution. Unfortunately, it was not there in the final constitution. There where the bar came and the bench came. We know Mohini Jain, Justice Kuldeep Singh judgment said that yes, right to education is a part of her fundamental right under Article 21, right to life and liberty. You can't have life and liberty without education. But before that, in 1986 and 1978 and 1984, there were judgments of Delhi High Court, there were judgment of Karnataka High Court by Rama Joyce, Justice Deshpande in Delhi High Court, said that yes, right to education is a part of fundamental right. But Mohini Jain said right to education is a fundamental right built in Article 21, right to life and liberty. It said complete education. That was watered down by Justice Jeevan Reddy in Uni-Krishnan case, says education up to the age of 14 years, relying upon Article 45 of the Constitution. It was the judgment in 92, Mohini Jain, and 93 in Uni-Krishnan. But it took another 10 years, 86th Amendment to come in 2002, to bring in Article 21 capital A, which says children from 6 to 14 years are entitled to right to education. There where, suppose these judgments are not there, Parliament may not have stepped in to provide education as a compulsory education. It was in 2002, but then again it slept over because all parliamentary legislations, even the constitutional amendments, come into force when the government notifies it. Government has not notified. 2002, 3, 4, 5, 6, 7, 8, 9. Right to Education Act comes in 2009, after 7 years. Again not notified. It notified only from effect of 1st of April 2010. So 2010 becomes an enforceable right to education. And thereafter, the education as a matter of right we can claim as a fundamental right that every children from 6 to 14 years have a right to go to school in a neighborhood school. That's where the judiciary, bar and bench stepped in. That's where the legislature was awake, and thereafter it enacted the act. To say that the legislature or the bar or bench has nothing to do with the legislation, no. As my own friend Manoj Surpa said, that mock parliament is very important. I wish you organize such functions again. We prepare a draft bill, and I'll show you about 2 subjects. Debate it in this house. Let's there be Treasury House, there is no opposition, and give it to the government. That yes, such a bill, we need it. We the people of India need it. Each one of us are as much part of the government as anyone else. We elect them. So our say has to be heard. So this is one aspect. Then comes the EWS reservation in 2021, upheld by the Supreme Court in 2022. Education has become a right, a fundamental right, only because bar and bench went together and gave these judgments about Mohini Jain, about Unnikrishnan, and so on and so forth. So it is not that we are outside the legislative domain. Each one of us has as much interest as do it. Another thing, a small thing perhaps, there is a crime in the IPC, erstwhile IPC 1860, which you commit the crime, no offense. But if you attempt and fail, it's an offense. Lady has been, my colleague has been noting it. What is that right? Can you tell me? Suicide. Attempt to suicide, great. So if you commit suicide, no offense, mar gaya. But if you attempt and fail, you will have to go to jail. That was struck down in 2002 by 1994, not 2000, 1994 by 2-judge bench, saying that it is unconstitutional. People doesn't commit suicide just like that. It is under great stress. You need to reform. You need to console that person. Why you are committing? Society is there to. It is under great stress. It was struck down by a 2-judge bench, but then thereafter it was reversed by a 5-judge bench in 𝐺𝐸𝐷 in 1996. That no, if you attempt and fail, police is there to catch you. Attempt and succeed, fine. So that was again picked up by the Parliament in 2017 under the Mental Health Care Act. They amended the section 115. They say there will be presumption if you attempt to commit suicide and fail. There's a presumption you have done it under a stress, and you will not be prosecuted. So that presumption has to be reversed by the prosecution. So attempt and fail, yes, 309 remains, but effectively no. Everyone does it under a stress. कोई ना कोई स्ट्रेस होता ही है. एजुकेशन का हो जाए, पार्टनर का हो जाए, और किसी रीजन से हो जाए. हंसने में ज़्यादा आ रहा, पार्टनर से कम होता है, एजुकेशन से ज़्यादा होता है, और रीजन से ज़्यादा होता है. You are not able to fulfill some requirement, domestic household, but that is always under stress. So Parliament recognized that it is a presumption that you are under a stress, and under the BNS now 2020 Bharat Nyaya Sanhita it has been deleted. There is section 226 which says it's only if you attempt to commit suicide to compel or restrain any public servant from discharging his duty. Yes, आप टैंक पे खड़े हो जाओ कि मुझे तो ये देना पड़ेगा नहीं तो कूद जाऊंगा मैं, like Dharmendra, then it is an attempt to commit suicide, but not otherwise. It is always under stress. So these are the 2 instances which I think we should remember, saying that the Parliament, bench and bar has a very important role in the legislative field, in socio-legislative reforms. That is the aspect I wanted to cover. Now, what can we do for the future? We have a life on this planet Earth. I was finding out how many planets we have. I think all of us think that there are 9 planets. 8, oh, that's correct. I got corrected. I was under an impression 9. There are 9. One is officially de-recognized. Pluto has been de-recognized. I think that I thought that I have a lot of knowledge, but then you people have a lot of knowledge. I need to stand there, and you give me as a lecture. There are 8. One has been de-recognized because it does not meet certain parameters of planet. We'll discuss that science. I am very poor in science, almost in every subject, but that point. But But then, according to us again, life is only on Earth. Why? We have water. On other planets, we can have life perhaps in movies. We had Jadoo in 𝐁𝐞𝐧𝐜𝐢𝐞𝐳 𝐿, we had PK in PK. But then we do not know. For certain we know that there is a water or in liquid form on Earth, and that's why we have life here. On Moon also they are trying to find out whether there is water, there is life, but we don't have any knowledge of any other planet having life. And one of the reasons is there is no water. Now, what is the water? We have 75% of Earth is water, ocean, but that's saline water. Only that's a recent study by NHRC, I'm not saying there's a published study by National Human Rights Commission, which has said 96% of that 75% water is ocean water, saline water. So we are remained with 3.5% of total water content as a non-saline water, we can say drinkable water or normal water. Out of that, again, 3%, that is 3.5% ka, 3% is in the form of caps, ice caps, glaciers, etc. So liquid form, we have only 0.5% of the total water content. And we see in and out, there's a lot of fight between neighbors for water. Pani nahi aaya. Fortunately, all of us has tap water. I'm coming to that. We see, and I feel very sad when we see our brothers, sisters, mothers going 10 kilometers, walking 10 kilometers, carrying 20 liters of water on his or her head. Mainly we see ladies carrying, because perhaps the male go for work and ladies go for collecting water. How can we have a country where 75 years of independence, we don't have water? And water is what? Nature is giving. You don't have to cultivate. You don't have to. पास में ज़्यादा हो गया. Sorry. मैं तो बंद करके भी बोलूँगा तो आ जाएगी. मेरे दोस्त काफ़ी अच्छे हैं, सुनते हैं मुझे. All right. So, how can we have an independent country for 75 years and we don't have potable water? I was seeing a KBC series where one of the persons won about lakh of rupees or 3 lakh rupees. And they said, क्या करोगे? मैं घर पे जाके bathroom बनाऊँगा. क्यों? I see my sisters and my mother taking bath on the open. It's very sad. We talk of so many things, our luxuries, our right to life, etc. And the courts have repeatedly said right to water is a right to life. All right, paper mein likhne mein it's a different thing. But are we able to enforce it? We don't have water for 2 hours, forget about 1 day. We all will be crying here, there, and we'll fight with our neighbors. Tanker aaya, lagao line pe, and we see the tankers fighting so much between the neighbors. One of the reasons is water. There's so much of crisis. People talk of tanker mafia and so and so, but simple water which nature gives us by dropping, literally drops water. And we don't have that. What kind of country? We must have a legislation where right to water is there. There are so many schemes. Har Ghar Jal scheme was announced by the Prime Minister in 15th August 2019, that by 5 years' time we will have tap water in every household. That was a very good suggestion. We are not thinking of Har Ghar Jal was announced on 15th August 2019 from the fort of Red Fort. And at that time, I'm really elated that at that time, as per the data again, 2 years before this subject came to my mind, day before yesterday, there was an Indian Express cover article. And there was a cover story about this article. Har Ghar Jal, परसों का पेपर है. And they gave the data. Before 15th August 2019, we have about 4 crore tap water. Around 20 crore we have rural household. So we have only 4 crores. So out of 20, 16 crore household, that means each household we have, say, 6 persons. So 120 crore people doesn't have tap water, that they go to the river, take bath there, they go out to ease themselves out. What type of country we are living in? But fortunately, with the data says, in last 5 years, from 2019 to 2024, about 12 crore new tap water connections have been given. That's a very big achievement. That's a very big achievement. For 5 years, we can do 12 crores, and which we did in last till 2019 for 70 years, 4 crores. It's a big, big number. And water is very important. But still, we have only 75% people or households having tap water. And kitna der pani aata usme to pata nahi. But still, we have a tap water. It may come for an hour also. It's sufficient. Even if 1 hour it's sufficient. Just think of water I'm having in, within 5 minutes I'm requiring water 3 times. Just think of a person who doesn't have water at his or her house. The lady will go to a river, bring it, keep it, उसी से नहाना होगा, उसी से आपको fresh होना होगा, उसी से पानी पिएंगे. Cooking, everything is by that. So we must pass a resolution, we must provide a tap water in the next 2 or 3 years. That has to be one of the priorities in the country. It's really shameful that we don't have water, tap water connection. People has to go onto the streets, fight, get up at 2 o'clock, put a queue. In Bombay, you see, in Delhi, anyway, Delhi, Bombay में तो क्या कि media is there. We always say Delhi में छींक भी आती है तो अब media में आ जाता. People, I come from Assam, people die out of water because there's so much of flood there. At one part of the country there is flood, other part of the country there is no water at all. So we must do something. If there is a water cess to be levied, levy it. We are prepared to give it, but use it properly. That's one thing which I would require this forum to take it up, pass a bill, pass a draft bill, and carry it further. Another thing is housing. We are human beings. We have houses. No other living creature has houses as such, because we stop ourselves from being adverse natural calamities. We live in comforts, houses. But then we see houses being demolished. That's a very sad state of affairs. Court says you have built it illegally. All right, we have built it illegally, or builders have built it illegally. What we were doing when it was being built? We have municipal authorities. Their primary function is to see that municipalities are built. मेरा टाइम खत्म हो जाए तो बता देना. मुझे इतने दोस्त अच्छे मिल रहे हैं, अच्छे स्पीकर मिल रहे हैं. I'll go on. Another 2 minutes. Okay. In the Supreme Court we have a huge कि भाई जज बोलेगा हो गया बैठ जाओ. तो but then I am with my friends, so I am not getting it. Another 2 minutes I'll take. But then another thing is housing is, I feel personally very upset about it when I see a building being demolished. We don't have houses to stay. We don't have a roof. When I cross AIMS, I see people on both sides of the footpaths sleeping there at 50-degree temperature, at 5-degree temperature. And we have another time bulldozer coming or a blast, putting the house, demolishing the house. What is this country we are talking about? It may be illegal, but then people have a roof. And what were the authorities doing when it was being built? Can we think of putting even one wall without the nexus of the authorities? We cannot. So first thing which should be done is take the responsibility of those who have not discharged their duty. The municipal authorities, the inspectors to the chairman of the relevant time when the illegal construction was made, he or she must be suspended. That is the first thing you do it, and then you demolish. All right, you come. It's very easy to demolish. I saved my lifetime there, built a house, 1-room house, 2-room house, and it is demolished after 10 years, 20 years, 15 years. Judiciary is also to be responsible. Why? After 15 years, you allowed it and you are not taking any action. You just say they must be prosecuted. Have you ensured that they are prosecuted? They have taken money for failing to discharge their duty. Their duties, their official duty is to see that there is no illegal construction. If there is illegal construction, first responsibility is of the municipal authorities, the statutory authorities, whose duty is to see that there is no illegal construction. Rest have made illegal construction because financially it may have been compulsion, whatever reason it is. And we have seen in Noida, there was live coverage, media showing that yes, blast hone wala hai, blast ho gaya, building gir gayi. So painful to see it. Just think of your houses being demolished in that manner. You have taken loan, you have to repay the loan. Your bank will not let you off your loan. And another thing is, we see structures. We saw 2 days back Mustafabad, and building collapsed, 15% to 11% died. Who are responsible? The municipal authorities are firstly responsible. Why did they allow 2 extra floors to be constructed? They have taken money. Have you prosecuted them? 11 persons have died. Then we go with bulldozers and demolish. But what they were doing when it was being constructed? Are we waiting for Israeli missiles to come in Hamas, or Russian missiles to go? It is something similar to that. If you compare the 2 videos, one which a house was demolished in Noida, it just fall like that, and another missile is attacked by the Russian missile. It goes like that. It's something similar. We cannot afford to have demolish our houses. We are really short of our houses. We are short of our roofs on our houses. We see people on the roadside. There are Rain Basera which were being built. They are being built as a very good thing. But then people are roofless. At 4-degree temperature, you please see, your heart will break. 4-degree temperature, small child of 10 years, 6 years, 6 months, sleeping on the footpath with her mother or with the parents, charged in 40-degree temperature also. So this is 2 things which I think the bar and bench together has to take it forward, and we will take it forward. And once the forum like this takes it forward, the country will listen to us. And that's all I think I have to say. I've crossed my limit perhaps, and I'm really, really thankful to Nehra for giving me an opportunity, to all of you. Please, thank you very much.
Thank you so much, sir, for your words of wisdom. You focus on right to education. You illustrated the bench and bar is not outside the domain of socio-legislative reform. Sir, you touched the right to water, which is very heart-touching for me. I know the pain because I come from the area of very much of scarcity of water, drought-prone area. So we know the pain for that. I wrote a research paper 10 years ago, right to water as a basic human right. And therein I mentioned, the suggestion was given that there is a need of a special legislation to activate it or implement it. But still I haven't seen anywhere. You have touched the right to shelter and issue of demolishing of houses. And we definitely, sir, being the part of this society, will take it forward and will ensure that we'll do something better will happen in these issues. Moving on our next speaker, Ms. Mahalakshmi Pavni. She is a senior advocate who holds the distinction of being the first woman from Karnataka and the 6th woman to be designated senior advocate by the Supreme Court of India after full court bestowed upon her the coveted senior's crown on 23rd April 2015. In Ms. Pavni enrolled with Bar Council of Karnataka on 21st August 1992. In 1998, Ms. Pavni joined the chamber of late Shri P.P. Rao, senior advocate, her father-in-law, and commenced the practice at Supreme Court of India. Ms. Pavni had the esteemed privilege of assisting Ms. Shri Rao on a number of important matters before the Supreme Court. She, in 2005, just a minute, ma'am, she enrolled as an advocate on record of the Supreme Court of India after having achieved distinction in AOR examination. In 2014, she elected as a president of Supreme Court Women's Law Association. I feel honored to request you to, ma'am, long list.
I know, that's why I didn't want the audience to get bored.
She completes 10 years today.
Yes, thank you so much. Thank you. Namaste to the distinguished guests, Justice Tandon, Hansaria sir, Nehra sir, Manoj Swarup sir, Shilpa, my dear friend Rachna Srivastava, my dear friend Ms. Sonia Mathur, then we have Sasmita Tripathi ji, treasurer, Seema, my young friends, Pragya Baghel, Ranjita Rothgi, Savita Devi, Seema Patnaha, Vidya Power, and Dr. Prabhat. Ma'am. Yadav ji, namaste, and thank you all for giving me this opportunity to speak. And respected Bhati sir, where are you? Respected members from the Society for Socio-Legislative Reforms present here. Thank you for assembling here, and it is with a deep sense of purpose that I stand here to address a subject of paramount importance, which is indispensable and intertwined roles of the bench and the bar in the forging of socio-legislative reforms. We gather at a juncture where the tapestry of our society is constantly being rewoven, influenced by the relentless currents of social change, technological advancement, and dynamic changes in the notion of human rights and justice. In this dynamic landscape, the bench and the bar stand as twin pillars upon which the edifice of law and societal progress rests. The bar and the bench are the two wheels of administration of justice, which have always worked together to secure for the people of the country liberty, equality, and justice, social, economic, and political. To really and truly appreciate their role, it is pertinent to acknowledge the symbiotic relationship they share between the bar and bench. The bench, an instrument of wisdom and impartiality, interprets, applies, and defines the law. The bar, an embodiment of diverse voices and concerns of the citizenry, through advocates, challenges, and reshapes the very discourse that informs legal interpretation and legislative action. The bench's role in socio-legislative reform is multifaceted and deeply ingrained in its constitutional mandate. Through its pronouncement, particularly in landmark judgments, the judiciary breathes life into the abstract principles enshrined in our foundational documents. Today happens to be the 52nd anniversary of the celebrated and historic judgment of Keshwananda Bharati. It was on today that the Supreme Court of India propounded the basic structure doctrine, limiting the amending power of the Parliament and safeguarding the fundamental tenets of our Constitution. This judicial assertion is born from the rigorous arguments presented by the bar and has had its legislative implications, ensuring the enduring spirit of our democracy. Further, the judiciary acts as a sentinel, perusing legislations which are blatantly unconstitutional or violative of fundamental rights. The invalidation of marginalized communities, discriminatory practices, and upholding of environmental safeguards through judicial review are all the powerful examples of the bench actively shaping the socio-legislative landscape. As Justice Hugo Black of the US Supreme Court eloquently stated, the judiciary has the duty of implementing the Bill of Rights. This implementation often necessitates a re-evaluation of existing laws and can spur legislative action to address lacunae or injustices identified by the courts. The bar, on the other hand, acts as the vanguard of societal aspirations and grievances. Lawyers are the first responders, the articulate voices of the voiceless. Bring the attention of the courts and the legislature, the lived realities of individuals and communities, highlighting the inadequacies and iniquities within the existing legal framework. The role of the bench and the bar, as Mahatma Gandhi said, the law is a weapon. Use it to protect the weak. Use it to fight for justice. Lawyers can use their expertise and knowledge to advocate for the rights of marginalized communities, challenge unjust laws, and promote social change. They are the twin energies driving the chariot of social progress, constantly striving to align with the law with the evolving needs, aspirations, and demands of the society. Through their independent yet interconnected functions, they ensure that the law remains a dynamic instrument for achieving justice, equality, and a more humane and equitable society for all. The tireless efforts of lawyers and activists who have fought for decades to strengthen the protection against domestic violence, combat gender-based violence, and secure reproductive rights for women have been pivotal in transforming society. Their persistent advocacy, grounded in the principles of bodily autonomy, gender equality, and human dignity, eventually led to crucial amendments in the law and policy reforms. Landmark judgments such as Indra Sarma, which reinforced the protection of women from domestic violence as a civil remedy, Lalita Topo, where the court expanded the scope of maintenance of the Domestic Violence Act to include live-in partners, Hiral P. Harsora versus Kusum Narottam Harsora, where it allowed women and non-adults to be held liable under the Domestic Violence Act, and which broadened the protective ambit of the law. The interplay between the bar and the bench is not always harmonious. It is often characterized by robust debate and intellectual sparring. However, this very dynamic tension is essential for the evolution of law. The bar's critical examination of legal precedents and its fearless challenge to establish norms compel the bench to constantly re-evaluate and refine its understanding of the law in the context of changing societal needs. This dialectical process ensures that the law remains a living, breathing instrument of social justice rather than a static relic of the past. In fact, the persistent advocacy of environmental lawyers presenting scientific evidence and highlighting the devastating impact on communities has led to stricter environmental regulations issued by landmark Supreme Court decisions, that is the MC Mehta's case, which established the principle of absolute liability for hazardous industries following the Bhopal gas tragedy, the Taj trapezium matter, where the court ordered industries polluting the Taj Mahal to switch to cleaner fuels or relocate, emphasizing the precautionary principle and sustainable development. The latest is in M.K. Ranjit Singh, the Supreme Court recognized the right to live free from the adverse effects of climate change as a fundamental right under Articles 21 and 14. Similarly, in Navtej Singh Johar versus Union, the court decriminalized consensual same-sex relations by reading down 377. In fact, Justice U.C. Banerjee in 2001-10 SEC, that is Arun Devendra Oza, has aptly opined that there should be a proper amity between the bench and the bar rather than any element of arrogance or superiority on one side. Proper coherence will bring best out of the judiciary and make the justice delivery system of the country more effective. This underscores the importance of collaboration and respect in the judicial process towards a shared goal, namely the fair and timely administration of justice, which can enable the bench and the bar to drive meaningful change and promote justice, equality, and human rights. In fact, there are notable orders under 142 of Supreme Court, that is the Vishaka guidelines, then the cancellation of coal block licenses that were improperly allocated, the Permanent Commission of Women Officers in Armed Forces, and directive to public officials with respect to demolitions. Justice Thurgood Marshall, a towering figure of the American civil rights movement, said, "Where you see wrong or inequality or injustice, speak out, because this is your country, this is your democracy. Make it, protect it, pass it on." As members of the bar in our own country, let Justice Marshall's powerful words resonate deeply within your professional commitment. I embody this call to action by fearlessly speaking out against injustice and equality whenever you encounter it within the legal system and society at large. I strongly believe that our bar, in its commitment to justice for all, embodies this powerful call to action. Let us therefore recognize, celebrate the vital contributions of both the bench and the bar in this ongoing endeavor, and let us continue to foster an environment where their collaboration can flourish, leading to a brighter and more just future for all. Injustice anywhere is a threat to justice everywhere. Thank you. And we live in hopes. There is hope for the best. A younger future, a younger generation is coming forward to take the fight. So let us hope that water will be there for all of us, and we also should ensure that we fulfill our moral and social obligations by caring for the next generation. Do not waste water, do not use plastic. There are so many things where you can do. You need to be the change that you want to see. So the change comes from within you. Thank you.
Thank you, ma'am, for your enlightening address. It's really a true intellectual feast for us, ma'am. You focused on the role and bar for the protection of marginalized people. You focus on gender-biased violence, domestic violence, and amity between bench and bar for the justice delivery system of this country. Thank you, ma'am, once again. Sailing ahead in the program, I would like to invite the person who is the delivering source of the knowledge, strength, competence behind the establishment of our society. He started career practicing as an advocate in the year 1968. He was appointed as a senior advocate in the year 2000. He was also appointed as an additional advocate general for the state of Uttarakhand in the year 2003. In the year 2004, he was elevated as the Honorable Judge High Court of Uttarakhand and got retired in the year 2008. Subsequently, in the year 2008, he was appointed as a presiding officer, Cyber Regulation Appellate Tribunal, Delhi. He has authored 4 books in law and also has been awarded prestigious Sahityik Puraskar by the government of Uttar Pradesh. He was appointed as a chairman of the Higher Technical Education of Uttarakhand in the year 2011. In the year 2012, he took charge as a member of Human Rights Commission Uttarakhand. He was appointed as the chairman, Law Commission for the state of Uttarakhand in 2017. This person with the diverse wealth of experience is none other than Justice Rajesh Tandon, former High Court Judge, Uttarakhand, and the chair of this seminar. Sir, I would like to invite you to deliver your address.
Thank you, Master of Ceremonies. Today's function is of this society which was founded in 2000. The name of the society, you will all know that Society for Socio-Legislative Reforms. The society was originally founded by Sri Manoj Swarup, the senior advocate of this Supreme Court. Later on, various opinions were taken and the meetings were organized, but due to some reason or the other, sometimes COVID and sometimes other problems, the meeting could not be organized. But the first meeting held today has obtained a century in the sense that all are present here and everybody is taking interest for this society, and Mr. Hansaria has given so many points to be discussed for this society, and the platform which he has given, for this society, really it is commendable, which we will discuss from time to time. On the dais, Mr. Manoj Swarup, Mr. Hansaria, and Mr. Kamni ji, Mr. Mahalakshmi ji, and Mr. Nehra ji, and all my sisters and brothers, and all the senior lawyers who are present here. The 4 points Mr. Hansaria has left to be discussed, and those points are very important. Number 1 was right to education. Right to education, it is a part of Article 21 of the Constitution of India, rightly discussed that it has been held, although it is not in the Constitution, Part 3 of the Constitution, but it is a Article 21. It has been held in the Mohini Jain's case and Uni-Krishnan Jain, although it is not in Part 3, but it is a part of Article 21 of the Constitution of India. Therefore, right to education, he has rightly said, we have to take some initiative to get this Article 21A, that is right to education, and also the right to education of the small persons or the minor persons or even the students who are coming for the law trainings and all that. We have to be guided that the trainers, the law students who are completing their education as a law, but they don't have any capacity or they don't have any knowledge how to be trained. Now this society will take up this matter that the lawyers who are coming as a raw hand completely after studying 5 years and 3 years will have no source of training, and this society will take up the issue and the senior lawyers will take a round of 10 or 15 lawyers of the trainees, that is the students who are coming after completing their law education, so that they may be given full training as an advocate, how to behave in the court, how to develop the arguments, and all these things this society will develop for the students and for the law students who are coming up. Although moot court has been provided by the Bar Council of India, but the Bar Council of India, in the moot court, only some of the students take part, only some subjects are being taken up, but the students are not being taken up for the training as an advocate, how to discuss and how to behave in the court. We all are aware that after the Constitution, in the preamble itself, the word dignity was there, and thereafter it has come up in the Human Rights Protection of Human Rights Act, Section 2D of the Protection of Human Rights Act, which provides life, liberty and dignity of the individual. Now dignity is for yourself also, for the court also, for everything. That dignity is there, and that is reciprocal. You have to maintain the dignity, and the court will also maintain a dignity with you. That is the bench and bar. That is the criteria which one should adopt. You have to maintain, and the court has also to maintain. One should not be dishonored, either liar or the court, and therefore the dignity of the liar and the dignity of the court depends upon you. All these trainings have to be given to the lawyers who are coming up after completing their education, and I hope that we will take up the students who are coming up after completing their education for their training, and will also do that they could get the books also for the study. Nowadays the system online is going on. They don't have the books. Only if the question is asked, they will ask from the Google, ask from the online, and they don't have the books. Now the criteria has completely changed. The students have no books, nothing of the kind. Even they don't have the bare acts, and therefore our society will provide a guideline to them how to come in the court and how to take the lessons and how to address the court after with dignity, and the Bare Act should be kept with them, and Bare Act is the guideline for them. If any question comes, then he has to search the Bare Acts, and he has to search that article and that section twice, thrice they have to read, then the arguments may be developed. The other thing Mr. Hansrajia has stated, that is right to water. Rightly he has said that the water is coming up so down that we have to be sorry for that, and that is our society has to do. We advocates can do much stronger position in that. We have to provide the water also in the villages and all that, where they don't have the water facilities, and they rightly he has said that they have to go in river for getting the water, and we have to see that the water is also available in all the localities, in the villages and all that. Apart from that, a demolition matter he has stated. For that demolition also, we have to be careful what he has said, that bulldozer justice. Anyway, we have to see that the bulldozer justice is not being done. Now there should be a criteria how the building will be constructed, and how the demolition proceedings will start, whether the construction is unauthorized, whether the construction is authorized. All these things, pros and cons, have to be seen. Only then a situation may come for demolition. We have to eliminate this bulldozer justice immediately. Otherwise, everything we have seen in Noida, the building has been demolished. At least it was 35 manzila building that was demolished last year in Noida. All these things are there, but we have to be, now we are the liars. We, the society, have to do all these things. From time to time, we have to have discussion on these things, and we will also provide whatever we can do. Apart from that, nowadays, various factors have come up in order to overcome the disposal of the matters. Now those have come up under the Legal Services Authorities Act. Various Lok Adalats have been formed. Now apart from Lok Adalat, permanent Lok Adalats have been formed. And permanent Lok Adalats are doing much better. Justice are being done. Cases are being disposed of, and the burden of the courts are being reduced from time to time. And for that purpose, every high courts should take the action, should appoint the permanent Lok Adalats. All the motor vehicles cases which are pending for 15 to 20 years, husband died, wife died, children have grown up, but the persons are not getting the compensation. They are not being paid what have been given for the compensation, and that is the criteria, and therefore we should provide much assistance to the Lok Adalat. Every high court should have a Lok Adalat. If you see the 22C of the Legal Services Authorities Act, that provides a permanent Lok Adalat. Why these permanent Lok Adalats are not being constituted? If 4 or 5 retired judges, retired district judges, retired judicial officers are appointed, it will be reduced, the capacity will be reduced, and the disposal will be done, and all the cases will be disposed of in a day. All these facilities are there. We will take up the issues from time to time, and this meeting, I thankful to all the advocates, all the sisters, and all the brothers who have come up for this in this society, and this society will bring much laurels for this junior students, for the litigants, and for all that. And I thankful to Mr. Manoj Sarup that he has, and Mr. Nehra, as for this first meeting, and let the meeting will continue with the cooperation of all of you. Thank you very much.
Thank you so much, sir, for your words of wisdom. Dr. K.S. Chauhan, Senior Advocate, has K.S. Chauhan has joined us right now. I welcome you, sir, on behalf of the society. I request Mr. Vikas Gupta to present floral bouquet to Dr. K.S. Chauhan, Senior Advocate. Is he there? Dr. K.S. Chauhan, a Senior Advocate, is Supreme Court practicing primarily at Supreme Court for the last 36 years. He has conducted a famous parliamentary privileges cash for query case relating to the Parliament of India, Lok Sabha and Rajya Sabha, wherein the members of the Parliament of India were expelled for the allegation of raising question in lieu of cash. He had aggregated many books in his name. Sorry, sir, but I have this much of information at the 11th hour. I feel it's an honor. I request you, sir, to kindly deliver your address.
Thank you, friends. I am not a scheduled speaker, but Mr. Nehra has requested me to join you. I thought I will join you in the gathering, but he is kind enough to invite me to the dais because there was no space that side. So, as we are discussing, the advocates are the torch bearers of rule of law. And there have been instances where the rule of law is breached. Now, there are many things which we see in the society, like bulldozer justice and other things. But since I conducted the Parliament's case, and there are many young lawyers, I want to speak on that for 5 minutes. In 2005, Parliament expelled 11 MPs. So 10 MPs have filed petition before Delhi High Court. And one of the MP I was representing, I filed in Supreme Court. So the issue was that there were allegations that the MPs have taken bribe, and then they have raised questions. That happens in every day in our media, because media does not verify anything. I was representing Rajaram Pal. The case is also reported with Rajaram Pal. So he has not taken any money. There was a sting operation. In sting operation also there was nothing against him. But still he was expelled along with the other 10 MPs. So these MPs, all 11 MPs contacted 8 senior most lawyers whose name are published in newspaper every day. But all of them have refused that even Supreme Court will not issue notice. So Mr. Rajaram Pal, I have met in a meeting. So he asked somebody who has invited me to that meeting, and then they came to me. Then they said that we want to file this case. Then I told him that I have not conducted any such case, but you give me 3 days, I will try. If I get some precedent or something, then we will definitely do it. So after 3 days he came. He has engaged one of our friend also. I don't want to name him. And that friend has drafted the petition that very day. When they went to him, like a labor petition, this is a Parliament privileges case. Even we don't do every day such cases. but he has drafted, got signature and everything. But after 3 days, then he came to me. Then I show him only 1 page of my note. Then he said, "Bhai sahab, मैं उनको phone करता हूँ. I don't want to name him in my speech." So he telephoned that, "Sir, this Dr. Chauhan has drafted something and we want to file that. We don't want file which you have drafted." So ultimately, we filed it on the 2nd January 2006. So we mentioned that very day. Chief Justice Agarwal was Chief Justice at that time, but he said it will come on its own turn. And ultimately on 15th of January 2006, the matter was listed. It was, notice was issued, and it was referred to the 5-judge bench, which we called Constitution bench, on the first day. Basically, the issue was that Parliament do not have power to expel a member of Parliament, and this is decided in the reference. If you know, in 65 there was a reference, special reference 1 of 1964. So that was decided in 65. In that, SCR has reported that this power is not vested, because this power is power of the UK Parliament as constitution of its house. And this power is not delegated to India, because under Article 105, this power is not inherited by our Parliament, because in our constitution, the qualification of member is prescribed and disqualification is also prescribed. And the legislation which was enacted by the Parliament, Representation of People Act 1951, in that there is no provision for expulsion. So that was the issue. On that basis it was considered by the Supreme Court. But ultimately, all of you, those who are senior, they know, and those junior, they must know that there are so many things which are decided on political basis. The basic issue was not considered at all. Though there was a dissenting judgment by Justice Ravindran, he, whatever my argument was there, because of my case, he decided another case in 2006, 𝐒𝐈𝐶𝐬 case. In that, the argument which I have developed in my petition, he decided that case on that basis. And because that was a 3-judge bench, and he has decided it, so they have not overruled that judgment. So ultimately, the case was decided against me with 4-1 judgment. And now also Parliament has expelled a member in the last Parliament. And every day, whenever a member is taking some public issue, they discuss about the expulsion. Every day we find in the newspaper. We are, as protector of rule of law and the constitutional values, we must stand up, because if a member of Parliament is not protected, what protection we can give to a laborer or a common man or a civil servant? Because the way the things goes on in the democratic system, there are so many allegations against the electoral politics. There are allegations against EVM, but courts are not adjudicating those issues on merit. So as lawyer, we must stand to the rule of law, and we must examine whether constitutionally a principle is permissible or not. Because that 7 judges' opinion says that this power is not vested with the Parliament of India. So that can be overruled, or that can be clarified only by a larger bench. 5 judges' bench cannot expel a member of Parliament. So that is the principle which we must adhere. So the young lawyers who are practicing, they should not bow down to any media report or anything of that sort. They must try to their best level, whatever is the principle in the Constitution which we are interpreting, whether that interpretation is possible or not. And in US Parliament, likewise, 2 members of their Congress were expelled. I find those cases, because of that, then after 3 days I said that we will file it. So those cases also the House has expelled those members. So because we find those cases and we analyze that this power is not to be exercised by a House, because there even expulsion is provided by 2/3 majority. In our Constitution there is no such provision. In their constitution, they have a provision of expulsion with 2/3 majority. But still, the court has judicially reviewed it and reinstated a member. But our constitution does not provide for expulsion. But still, the Supreme Court has not reinstated the member. And mind you, there was no evidence of any sort against that member. Though they were showing 2-3 MPs have taken money and put that money in his pocket like this, and that is shown in the media. So we must stand with rule of law. We must not cow down whatever may be the problem with your client. You must stand with your client and develop a constitutional principle, because that is the duty of every advocate who is practicing in the Supreme Court or the constitutional courts. We must not just understand that somebody is saying that this is not possible, or somebody is saying this is possible. We must abide by the rule of law, the constitutional principles which are expressly there, or which we have inherited from the other democracies. So that is the idea with which I think we must develop this society to a better level, and we must discuss subjects on a regular basis. Because if we are discussing subjects on regular basis, the young lawyers and the people who are interested in rule of law, they will be educated and they will work as better advocates for the future litigation. With this, I think that is more than sufficient. Thank you, because I am not a scheduled speaker, so I should not. Yes.
Sir, Rahul Gandhi was expelled.
Yes.
And was it appropriate decision?
No, individually I cannot say whether that was correct or incorrect, because we are in a system. And that system, I think that was a very good example, because Rahul Gandhi has torn that amendment. That amendment is a legal principle, and that is not only in our country. If you have appeal in the higher court and your appeal is permissible, then if the higher court states that interim order or final order of the lower court, then you cannot expel a member. At that time, they wanted that Lalu Yadav should not contest election. That's why that amendment was torn, because that was a principle which they were developing, and that is unfortunate. And that is a good example that he has faced himself, because in democracy, today Modi is ruling, tomorrow maybe he is in opposition. He may need the protection of the courts. So courts should be independent, they should work independently, and reasonable political things are going on, that is all right. But it should not be too much of politics. We must...
No hard decision should not be taken.
No, whatever we are deciding, we have to decide on a principle. And on legal principle, if we see whatever is happening, sometimes we feel that even the highest court is not deciding issues on legal principles. And if the court is examining, like the interim order in this Waqf Act, if you examine it, the way the member of parliament, he is an elected member of parliament, how he can speak in that language against a chief justice? And this is an interim order, it is the duty of the chief justice or any judge who is deciding. He has to decide on merit, and if he thinks that the interim order can be granted, then that is his judicial wisdom. Unless there is some extraneous reason. Extraneous reason, if it is there, then you can raise all those issues. But if there is no extraneous reason, then you cannot have that type of mindset that you will abuse a judicial authority like that. So I feel, I think I have answered your question, because I am not answering on an individual basis. But the result the individual has faced is the real result which a person should face in that situation. Thank you.
With the permission of Chair, I just want to correct. Rahul Gandhi was not expelled, he was disqualified. And if a person is convicted for an offence for 2 years or more, the provision of law makes him disqualified automatically. So he was convicted with 2 year sentence. When the conviction was stayed, he was reinstated. So it was not a case of expelling, it was by operation of law, he has to go. And once the conviction was stayed by the Supreme Court, he can be.
Lakshmi Penty was also suspended. Lakshmi Penty was also disqualified.
I agree, sir.
Let's finish.
Thank you so much, sir, for sharing your anecdote about the cash for query case and responding the question of the audience. With the due permission of the chair, we may have some question from the audience.
No, if you have question, you can ask.
As you like. Otherwise, from the next seminars, all will be permitted to express their views so that we can have a chart of it, and we can also publish a short seminar for this purpose.
Anybody has a question? Okay. Moving towards the last leg of the program to propose vote of thanks, I would like to invite Dr. K.S. Bhati sir, who is very kind-hearted and generous person. He has been practicing in Supreme Court of India, High Court of Delhi, Central Administrative Tribunal and other fora in the areas of constitutional law, service law, labor law, family law, and he is honorary advisor to the Thomas College of Law, Greater Noida. Earlier, he has worked with the professor and dean at the IMS Law. He was the registrar of ILI, New Delhi, for the period of 12 years from 1991 to 2003. He was deputy director in the Institute of Company Secretaries of India for about 21 years from 70 to 1991. He was a legal specialist with International Bar Association Law and Law Society of Zimbabwe. He is associated with International Bar Association UK, associated with the American Bar Association USA. He has authored several articles and monographs.
That's enough.
Sir, please.
Thank you, thank you.
Bhatiji, before that, one of our friends want to ask some questions.
Questions,
to
yes,
one of
sir.
us.
So I was very impressed.
You can come here,
You can come.
so that we can hear you. Just put your question and then.
A very warm good evening to all of you. My name is Shaurya Mishra. I am a junior associate with Mahalakshmi Pavani ma'am, senior advocate. And the question I want to put up, because I was very impressed with SSLR, that it has been established for 25 years now. So I have been attending many conferences and seminars with respect to, my question is with respect to Advocate Protection Act. Like, what is your take? Because there has to be a role coming from the bench and the bar as well, and we being the members of the being active members of the bar, because I do believe in all of you. You all are active members. That is the reason you all are present here today. So if this could be a very wide discussion, but I want to know from the dignitaries, from the dais, like what is their take, how we can progress and how we can, like, what would be our step, because we advocates, we fight for everyone. So what about our own protection? And there have been many incidents in the past where in September only a woman lawyer practicing was kidnapped and killed. She went missing for many days, and many more incidents. So what is your take? Thank you.
Mr. Hansaria is also sitting here. I will just pose 2 or 3 questions. What she has said about advocates' protection. There are several questions for advocate protection. Number 1, which I am always crazy for the students and the lawyers, about the lawyers who are coming after the 3 years or 5 years training. There is no occasion to give them stipend. What will be their welfare? How they will manage the things? Mr. Hansaria may also throw some light on this. What will be the criteria of those persons? A doctor who has just taken her education and all that, goes to the hospital, he gets the stipend. But there is no stipend for the advocates who are coming just from 3 years, 5 years completing the education. What will be their role? How they can manage their fooding, lodging? The government has said the various judgments have said 3 things are essential, that is right to food, right to shelter, and right to lodging, proper lodging. How they will manage without any stipend, and there must be some criteria of the High Court, Supreme Court, and our Bar Association also for giving the stipend to the students who have just entered in the profession, number 1. Number 2, their welfare about the training is also there. How they will get the training? The senior advocates must contribute themselves. Once upon a time I was arguing before Justice 𝐒𝐞𝐽. Justice 𝐒𝐽 said, why you people don't take the classes of the students who are entering in the profession? He very in a huge voice he has said. Now those days have come up now. The senior lawyers must take the 10-15 persons who are coming for the education after completing their education, and they must guide them how to address the court, what is the dignity of the court, how to manage the dignity. All these questions we should start the training, and that training should be start from the office of Mr. Hansaria from tomorrow.
As it happens, judges always ask questions.
Sir, I have a question to Justice Tandon.
Yes.
Had you taken such concern when you were in chair? After retirement, you become so socialist. There be a single instance. No judges had taken such kind of concern when they were possessing chair.
When you were
Mr. Nehra will answer that.
Had you taken such concern when you were in chair? Simple question.
He says when you were a judge of the High Court, had you taken this concern?
He chairing, being the chairperson
wants to
of
know
the
that.
society. Not in any other capacity.
I am just Sir, everybody wants Advocate Protection Act.
मैं जब एडवोकेट था तब भी सबको ट्रेनिंग देता था, और जब गेस्ट थे तब भी लोगों को क्या
Let's conclude with a happy note.
So let's we have
भट्टी जी 2 मिनट। अब वकील को चांस मिल जाता है तो छोड़ते नहीं।
ऐसा है, एक रिजोल्यूशन पास करिए एडवोकेट प्रोटेक्शन एक्ट के लिए एंड सेंड टू द गवर्नमेंट, कंसर्न गवर्नमेंट, बार काउंसिल एंड बार एसोसिएशन ऑफ इंडिया।
चलिए आप चेयरमैन बनिए, आप बनाइए ड्राफ्ट।
चेयरमैन नहीं सर, आप लोग सोसाइटी
नहीं आप ड्राफ्ट बनाइए ना सर।
Kindly prepare a draft.
Let us not divert what my friend has said.
आप बताइए।
Advocate Protection Act, it's a very important thing. Now, what are the protections we are looking for? Are we looking for protection in terms of finances? Are we looking for protection in terms of our safety? So safety is also important. We do so many cases about against the criminals, for the criminals, etc. Safety, say as a common man of the country, we should face the same level of safety. I don't think as a lawyer we should demand some extra layer of safety. It will not be fair to the common man. Why should a policeman should be there behind me and if I'm doing something? So important is I have always been allergic to this VIP treatment, etc. etc. So that, what about the financial part of it? That's very important that people, especially first generation lawyers, always has a problem with that. I always feel that. And my friend has said, can I complete and then I'll take your question.
Sorry, I'm just adding to what you are saying. It's like my father has been a practicing lawyer for past 40 years, and then he met with an accident and he's now into disability for past 13 to 14 years. And now there's a struggle, there's no pension, nothing as a support, medical insurance. So I just
let me come to the different things which I thought that I would raise this issue, but I didn't want to raise a lawyer's issue and a lawyer's thing कि आप अपनी बात ही करते हैं, बाकी जनता की बात नहीं करते हैं। एक चीज मैं कहना चाहता हूँ, and if that is done, that's very important. I have always been thinking, central government health services, and like the Bar Association Home Super says that Mr. Nehra says, I will take it up, we'll all vote for him. Central government health services gives you at almost 25% of whatever the rates are applicable. If you go to Dr. Lal, you pay 500 rupees, and if you are CGHS member, you pay 100 rupees only for the
We are not giving any.
Just a minute, I am coming to that, madam. We are not getting. We are not getting central government health services. Just a minute, let me complete. We are said to be the officers of court. खाली बात बोलने से नहीं होता है. If we are officers of the court, judges are getting health services, central government health services, CGH is free. They are empaneled. Let's talk something which can be done on ground. Stipend, etc. One can say it's a private practice. How can you force anyone? So and so, so and so. Let's take something very, very specific. Central government, we are treated as an officer of court. Day in and day out. Yesterday I was defending. Mr. Counsel, you are first officer of court and then they count. Then you are the lawyer of your client. Because judge started asking questions, why are you doing this? I said, I'm answering. No, you don't answer. I'm asking. You are officer of court. I'm saying officer of court. I'm also representing him. But if you tell me I'm an officer of court, are you treating me as an officer of court? Not at all. Dignity part, Justice Saab kaha ki we will come to it some other day. Dignity part. But on ground, if something can be done, and there is a reasonable basis for doing, we are enrolled under a statute. We have an enrollment under a statute. Without that statute, we have no right to practice anywhere. If we can get as a member of, let's start that, as a member of central government health services, it doesn't require cost money to the government. It only requires a status which will facilitate us to get benefits in medical, tests, in hospitals. In some of my friends went there for max for consultation. Normal was 1500 rupees consultation. He was CGHS member. He paid 350 rupees only. Why? He had that card. CGHS card है मेरे पास 350. Let's do something as a member of the legal fraternity on ground. If this is done, this is doable. See, taking 10 or 15 juniors, I always say, anybody has any problem, come to me, discuss with me, whatever to best of my capacity, I will be able to assist you. If I can assist you, any member can come. I don't think any member has ever said to me, if you don't have, your client doesn't have fee, my services are always there. I love to. Bhattiji, sorry, I'm taking.
Please, sir.
I learned all this from Bhattiji. Bhattiji has been a very mentor to me. Personally, perhaps you may not know it. I'm very, very close to Bhattiji.
So kind.
And actually on the ground, if something can be done, if we can be enrolled as a member of CGHS, for which the government of India only has to issue a notification, it will not cost them a single penny, and it will give us a lot of benefit as a member of the firm. It will give us a lot of benefit at all ages, and this is one thing which can be done for the advocates' protection, according to me. बाकी कहना कि आप 15 जूनियर रखिए और इनका इतना दीजिए, that's all individual basis, very difficult to enforce it. Let me tell you, my friend, it's very difficult to enforce it. We can give lectures and we can win our bar association elections, but then it's very difficult. So ultimately we are individual practitioners. हम किसको कितना देते हैं, it all depends on your work also. I have my two of my juniors are here, but then they always run away. I call them either out. थोड़ा सा टाइम लगता है उनको आने में. Hard taskmaster. My interns are very, very difficult with me. I find it very difficult. एक दो इंटर्न को तो वो अगले दिन से उनकी तबीयत खराब हो गई. इसीलिए CGHS यदि हमारा हो जाता है, CGHS यदि हो जाता है तो nothing like that. All the legal, about 10 lakh lawyers or 15 lakh lawyers in the country would be benefited. Their parents, their children, their mothers and their parents would be benefited. CGHS के लिए हम, let us take all of us sign it, start with Nehra साहब and make a signature campaign. आप यदि हम तभी वोट देंगे, आप हमें CGHS member बनाएं.
Even in the Supreme Court, we have a
CGHS होगा तो कहीं भी जाएंगे. But teacher, sorry.
नहीं sir, it was very important. It was very important, sir. So very good evening, friends. First of all, our extreme gratitude to each one of you. You have spared your valuable time and encourage us to organize much more programs like this, as our chairperson has already stated. My Lord Justice Rajesh Tandon ji, the chairperson of this organization, our very respected senior advocate and a great lawyer, great humanist, Shri Vijay Hansaria ji, my sister Mahalakshmi Pavani, the person who cares for the women like anything. She is the president of the Women Association. and authored a book which is a treatise in the women welfare and women laws. Our very respected friend Dr. K.S. Chauhan ji, our founder, Secretary General Shri Manoj Swarup ji, our Secretary and convener of this program, Shri S.S. Nehra ji, and very, very distinguished friends around here. I acknowledge the presence and contribution of each one of you in making this program a grand success. On behalf of you all, I express heartiest gratitude to the panelists here. I acknowledge the presence of Professor Vani, the great scholar, former Dean of the IP University, and now the Vice Chancellor of ILLM University. I also acknowledge the presence of my very, very dear friends all around here. Especially I want to thank my friends, those who assisted us in organizing this program without any interest and any ambition, particularly Dr. Abedul Luli, Dr. Hiralal Nimba, Mr. N.P. Verma, Mr. Gildial Jyoti Deepak, and other friends, those who assisted us in organizing this program. And on our personal request, Dr. R.R. Kishore, he is one of the members of this society. He spared his valuable time besides youngsters, those who are present here. The subject has been deviated from the given assigned topic in a big way. We are taking the discussion, what is the role of bench and bar with regard to the socio-legislative reforms. I can say with pride that the Indian Supreme Court has done wonderful contribution and service to the nation in the judicial administration. And for the forthrightness of this, the Chief Justice of India has been threatened. And nobody from the bar, nobody from the society has raised a voice. The bench which has contributed to the development of the law, protection of the interests of the human beings in the society here in India,
The petition has been filed for that.
and the most respected institution under the Constitution in India. And I feel so sorry that the bar has failed. Not a single person from the Indian bar has raised any voice against that threat which has been hurled on the head of the institution in the country. The judiciary is contributing and protecting the human rights, protecting the law, and that very judiciary is under threat. And by those who have sworn themselves that they will abide by the Constitution, they will uphold the Constitution. I urge upon the leaders of the bar that Supreme Court Bar Association is not only meant to organize the festivities and the parties, they must their voice against any injustice, against any unlawful thing which is taking place in the country and in the society. My job is very small, that I have to convey my thanks to each one of you for your gracious presence here. What I have said is my personal view. It doesn't reflect the view of the organization. So friends,
First of all, my apologies that the learned Attorney General, Mr. R. Venkatramani, was unable to join the function. All of a sudden, he got a call from the government and he had to go for that meeting. And he was very regretful. We met personally also to him and he regretted, and on behalf of his absence, I seek the apologies of this House. Rachna Srivastava ji has probably left. We are grateful to her presence here. She is Vice President of our Bar Association. I also mentioned that Mrs. Ravi Shankar Singh, our young friend in the bar, he has been helping us in organizing this program. I thank you very much, Ravi ji. Our friend Mr. Dr. R. Ravindra Pratap Singh, the principal of Shri Ram College from Muzaffarnagar. He is here. I acknowledge your presence, Dr. Ravindra Pratap Singh. Thank you very much for coming from Muzaffarnagar to attend this program. I also acknowledge the contribution of Madam Lalita Kohli ji, our treasurer. She has been doing lot of work. She demanded my contribution 5,000 rupees many a times, which I failed to pay. I compliment you for your dutifulness. Thank you very much. Dr. K.S. Chauhan, I am grateful really. Because Mr. Rakesh Khanna was to go to Jabalpur. He had to go suddenly. So, he was the substitute for Mr. Rakesh Khanna. We are grateful for your sparing your valuable time. The young girls, Ekta and Hema, they have been helping us in our program. I thank them like anything. I also acknowledge the good presence of our friend Balraj Malik ji, a very frank leader of the bar. He doesn't mince the words. Thank you very much, Malik sir. I also thank Varsha Chaudhary. She has been helping us like anything. The institution, I belong to this ILI for many years. I feel very privileged to have worked for this institution. They have been very helpful to us. They were not allotting this hall to anyone because of some LLM PhD classes were going on. But on our request, they have given the hall. I express my gratitude to the director and the joint director and everybody, those who have helped us. And director has requested Hansaria sir also to meet him that after the event is over. So kindly take a note of it. We are very thankful to the all workers, Tilak, our man from the ILI, and all canteen people also over here. And again I repeat that my very sincere gratitude in person and on behalf of the organization to each one of you for your gracious presence here. And apologies if we have missed any one of you who deserves a recognition, which we heartily recognize each one of you, and we anticipate and hope that in future we'll meet again and again. And Eyal साहब को thank you करना चाहता हूँ, गिलियाल साहब को thank you करना चाहता हूँ. Thank you very much indeed. And now, as per the program, a photograph has to be taken in the group, and thereafter we'll have a tea. Thank you very much. I thank Dr. Shilpa Bagare.
Now the words can threaten us.